This was reversed.
Absolutely. Oh, do not even insult this court by saying that, Mr. Bennett. Do not, because you would have gotten a hearing. Had you filed a motion, had you requested that it is an emergency hearing, the public defender's office does it all the time. The fact you don't know how to do that and think that this court is playing favorites, you're wrong. Court's going to stand in recess. That's right. Court does call the case of the people versus James Whitley.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm hearing with and on behalf.
This is people's emergency motion to modify violence in this case.
Your Honor.
Yes, sir.
I didn't file a response because we got this at noon yesterday, but honestly, we also yesterday afternoon received a discovery which we've gone over. There's some issues that I certainly have with the allegations contained in the people's motion. The simplest one is under paragraph 8. It lists 4 offenses: criminal history, A and B, the same offense. 22821 is a district court case that became a felony, was found over according to registered actions. It resulted in a plea to operating law, a second offense, 31621. So that is one, that's the minor issue I have. Their description of what happened on this date contains, I think, some confusing statements. Paragraph 3, they say that the children saw the witness the assault, but in paragraph 5, they correctly state the 13-year-old son heard some screaming, glass break. He went into the room and observed the defendant sitting on the victim on the floor. The daughter, who was either 10 or 11, the brother thought she was 10, mom says she was 11. Said that as soon as he got his car keys, he left. What I think this comes down to, quite honestly, in my cursory review, my assistant has looked in a lot more detail at these things. The statements contained in the police report are not 100% consistent with what the allegations are here as far as the case is charged or not. When he first asked whether or not he strangled her, she said, I will tell you that I will say that if you tell me I have to. This is not the case that they purported to be. This case is more consistent with what I explained to Judge Fink on Monday.
Magistrate Fink, but go ahead.
What's that?
Go ahead.
Miss Fink, did I say Mr.?
You said
Judge.
Oh, Judge, Magistrate Fink, I'm sorry. You're all your honors to me. So. I don't want to get too much into the case, but what I will say is there are a huge numbers of inconsistencies between what the alleged victim said throughout her interview. This is, again, as I represented on Monday, I don't think there's much of a chance of conviction here. I will tell you that she is here. She wrote a letter to you. I've given a copy to the prosecutor's office. I will indicate, just for the record, I explained to her that I wasn't comfortable talking to her about what happened because my belief is she may need to talk to an attorney. I believe she is supposed to talk to one on Monday. But she wrote a letter that explains how little afraid of Mr. Whitley she is. What's also not contained in the report is the report says that she called, the alleged victim called the police, and actually that her friend Michelle called the police. Michelle's known Mr. Whitley for 20 years, and her statement to the police was, Mr. Whitley is not like this. I've never seen him mad. He's always has a smile on his face. Stunned that it happened. The children said, don't hear him argue, never seen her do anything before. Never seen him do anything before. Mr. Whitley is not a threat to the community. We look at the factor of the likely sentence. This, I initially had scored it as 017, but then when I looked at his record, more accurately, because of the 10-year gap rule, he's going to be in grid B12, which is a 0 to 11 months intermediate sanctions. It's a Class D felony. I scored for the injury to her, and I scored, which I don't agree with, but it'll likely get scored, that he exploited a domestic relationship. B2, 0 to 11 months probation. And the people are asking not for a bond to secure his presence or to protect the community. They're seeking a bond that's punitive. They want to punish Mr. Whitley for what they think he did, which is not what happened, which I'm greatly looking forward to at trial to demonstrate, if they can even get her to testify to proceed. This bond was appropriately set. I guess I'll just go over what I went over with Magistrate Fink. Criminal record, 3 prior misdemeanor convictions, 2 of which exceed the 10-year gap rule that we're using a felony, guideline scoring, author operating while intoxicated. It's always showed up. The only history of substance use or addiction is what is related to alcohol use. Certainly he has had issues with alcohol in the past. He has no mental condition. It's not diagnosed. It's not dangerous. Also, what I just said relates to the seriousness of the offense, presence, or absence of threats. And Wilson's found on that. He has had no contact with her since this incident happened. He has been exceedingly proactive. My legal assistant has been in contact with the officer in charge since this happened. The day that it was indicated that the complaint was authorized, she tried to turn him in. Last Thursday, warrant not entered. Last Friday, warrant not entered. Monday at 8:30, warrant not entered. She gets notification that she shows up just a little bit after 10 o'clock with Mr. Whitley because the warrant was finally entered. So he is looking forward to defending what happened here because these charges are not what the people allege. He is an employee, he works 50 hours a week with daily infrastructure. He just told me that company was bought out. That's the old company. Yeah, it's in transition. He does have a daughter in the area. He has 50-50 parenting time with her on paper. She's 14 years old. She doesn't always like hanging out with dad because he has rules in his house. But he does have a child here he communicates with daily. His friends are here. His job's here. He has no ties to any other community. As I said, as far as the other thing, he's been proactive in turning himself in. And he's not had contact with the alleged victim. I have a stack of emails to him. I don't know how many emails. I'm sorry, Facebook messages, probably a quarter of an inch thick. She's sending him. I love it. I love it. All of these things. This is my fault. You only sent a text, a Facebook message to somebody else. I only got injured because you were protecting yourself from me. Again, I don't know what the true facts are. This is so new. What I do know.
Did he go to the hospital?
What's that? No, but I do have a photograph of his head split open from something that she threw at him, most likely a phone based on her statement to the police. It happened before these other things.
Go ahead.
She denied being strangled. She said that her head hurt not because of an injury, but because she was confused. Quite honestly, I think it was more that she was intoxicated. She did admit to drinking. She may have been less than honest about whether she drove intoxicated or not. But at the end of the day, quite honestly, Mr. Whitley's not a danger. He's a upstanding citizen of Washtenaw County. The prosecutor's office is seeking to punish him by $150,000 bond. It has nothing to do with what her allegations were at the time, and nothing with what really happened. I don't see in here. I've only had, 27 hours to look at this stuff. The people have had longer than that. And I don't read anything in here, the people pointing out her own inconsistencies about what happened. And which affects, again, the likelihood of conviction. What it does just come down to, Your Honor, is Mr. Whitley is not dangerous. He's going to show up. And he's been not dangerous his whole life. He's 43. This is the first time he's been alleged to have committed any act of violence against anyone. He has custody of daughters. The mother has it. She's never made allegations of domestic violence in the past because they didn't happen. So if I read the motion, it seems to me that the biggest focus is about his dangerousness. Jennifer's sitting right in the hall. She'll come in and tell you she doesn't consider him a threat. Again, if the court's willing to look at it, I can show you this letter that talks about her relationship with him and the fact that she's not afraid. Didn't ask her to write. She just wrote. I think she would also tell you that Michelle said that Mr. Whitley, that this behavior was inconsistent with who Mr. Whitley is, based on a long-standing reputation of not being dangerous. I ask that you leave the bond as it is.
Your Honor, I think what this ultimately comes down to is the people are very concerned for the victim in this case. I'm concerned that she's writing a letter. I'm concerned that she's saying that this is her fault. I'm concerned that she's saying that she provoked this in the form of throwing something at the defendant. To me, those sound like very telltale signs of someone in a domestic relationship who has been victimized previously. I think here, what we have is a woman who ended up in the ER, receiving 3 CT scans in the head and face area, 2 X-rays, 1 for the chest and 1 for the wrist, who had 2 kids who were around when there was a domestic dispute between her and her partner. And I think it is extremely concerning to me that the fact that when the victim said she had head pain, defense counsel characterized that as a symptom of intoxication. It was explicitly stated in the police report that the defendant ripped her off the bed, slamming her to the ground, during which she landed on the right side of her face and was unsure if she even lost consciousness at that point. That seems to be the root of why she would have gotten the CT scans, being concerned for a concussion. The victim also sustained multiple visible injuries, including cuts, bruises, red marks on her upper body and her neck. I think that count 1 on here is charged in the alternative of assault, GBH, and or strangulation. We do not need to prove simply strangulation in order to proceed on the felony here. We can proceed on the assault, GBH, which I do believe would be satisfied based off of the victim's requirement or required medical treatment as a result of this encounter with the defendant. Ultimately, I believe that the PR bond here is an abuse of discretion. And we did make an argument at arraignment for the $150,000 bond in this case, and I would be renewing that request today.
I may reply, Your Honor, briefly. I'm making it clear this alleged victim was previously the victim of domestic violence from her deceased husband. That can explain maybe some of her reactions and some of the issues that she had. her
What does that mean?
her children, and she said this had never happened before by Mr. Whitney. Never happened before. Okay.
But I don't understand the first part of what you just said,
Well,
and how that relates to this.
She may have some PTSD related to the trauma before, but that doesn't mean that what Mr. Whitley says happened is wrong, or what how she answered the question. The first, and quite honestly,
Mr. Bennett, I'm trying to figure out what you mean by some PTSD from before. You're saying her reaction to all of this is in reference to some PTSD because of stuff that happened previously?
The prosecutor is making some comments that are speculative about her being a classic victim of domestic violence, which she was in a prior relationship. So the fact that the prosecutor sees that is unsurprising. That's what I'm saying.
Okay.
And as far as that he ripped her off the bed later at the hospital, that's not what she said. She said they fell off the bed. I don't know. I don't know what she's going to say on the stand. And what's important about this, no influence whatsoever by Mr. Whitney. He has stayed away from her. He doesn't want to interfere with what she believes happened. And he's not trying to influence her to do anything. I find it surprising that they're alleging that she's in danger, the prosecutor, and they don't call her to show up. She reached out to a friend of my client's.
Call her to show up to do what?
Today, to say I'm afraid. I mean, I will say.
Mr. Bennett, you've been doing this long enough. You know that's not going to happen.
I don't know, at 3 o'clock with 24 hours notice, I couldn't have got a hearing in that.
Could have got a hearing on what?
If this was reversed.
Absolutely. Oh, do not even insult this court by saying that, Mr. Bennett. Do not, because you would have gotten a hearing. Had you filed a motion, had you requested that it is an emergency hearing, the public defender's office does it all the time. The fact you don't know how to do that and think that this court is playing favorites, you're wrong. Court's going to stand in recess.
Right.
Court recalls the case of the People versus Whitman.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm here in Newton on behalf of Mr. Whitley, standing to my right. Mr. Whitley, can you state your name before, please?
James Anastasio.
Let me just say this, Mr. Bennett. I've been on this bench almost 25 years, and never have I ever been insulted in the fashion you just insulted this court.
Why?
No, my turn.
Sure.
The very first case, when you say that defense counsel or anybody else doesn't get access to the court like the prosecutors, you are absolutely wrong. The first case I called today was upon receiving a notification about something that I had considered in a bond, was notified that that had been located. This court, to the defendant's benefit, set that hearing. Without notice to any side, I set the hearing. So to be fair to all of the parties, I receive motions all the time regarding bond. And this court just seeks to be fair, to have a hearing. Mr. Bennett, if I had had in my heart the desire just to lock your client up, quite frankly, because the decision came from a magistrate under the court rule without a hearing, I could have changed that bond. But I wanted to give the parties the opportunity to be heard. Now, having said that, so maybe you can put that in a little perspective. I heard you that you said you just got the discovery, can't go through it. Well, I'm going to give you about another 18 hours to go through it because I'm adjourning this hearing for two reasons. To allow you to go through the discovery, to give me a cogent argument as to why I should not grant what the people want. And secondly, because you have raised the ire of this court. I am not going to punish your client by what was one of the most ignorant statements I have heard about the conduct of this court from any counsel in all of my years. I will not, by any means, punish him for that. I do not make my decisions out of anger. I'm adjourning this to tomorrow, May 10th, noon. All the parties are ordered to be here. That is all. That is all. Noon tomorrow. Court calls case of the people versus Joshua Quick.
Good afternoon, Your Honor. And I'm the attorney of the
Matthew Expert, public defender, and quick, Joshua Quick.
All right, what are we doing?
Thank you. We just received an offer today. We just like a couple of weeks ago. So that on.
No objection, Your Honor.
Probable cause conference. We adjourn 23rd, May 23rd, 2024, 9 a.m. Bond continues.
Thanks.
Thank you. Court calls case people versus Herbert Rhodes. Herbert Rhodes.
Hi, Your Honor.
Good afternoon. Assistant public defender.
Mr. Rhodes, can you state your name, please?
Herbert Rhodes.
All right. I have before me a plea form. Is that what we're doing?
Yes, sir.
Plea form indicates that he will be pleading guilty to the charge of non-sufficient funds, $100 to $500. That's a 1-year offense. Upon a successful plea to that charge, count one would be dismissed. That's the court's full understanding of the agreement.
Yes, Your Honor. Thank you.
Sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name for the record again, please.
Herbert Rhodes.
All right, you can put your hand down. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of non-sufficient fund check, $100 to $500. That is a misdemeanor. It is punishable by up to 1 year incarceration, a $1,000 fine plus court costs. The fine could be increased to 3 times the value of the checks or the NSF checks. If that's greater than $1,000, that would become the maximum fine. You understand that, sir?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A4 District Court.
Yes, sir.
Still wish to plead?
Yes, I do.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
I do.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent and not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, sir?
I do.
You understand you're giving up your right to appeal of Ray.
I do.
Are you on probation or parole?
Yes, sir.
All right. Were you on probation at the time of this offense, sir?
No.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily,
I am.
of your own free will,
Yes, sir.
and because you believe that you're indeed guilty?
And yes.
March 23rd, 2023, at the location of 513 West Main Street, that being the Ace Hardware. What'd you do on that date that makes you think that you're guilty?
I wrote a check in knowing that the funds weren't there.
All right. And then after sufficient time, you did not make that check good. Is that correct?
That is correct.
And the amount of the check was in excess of $100?
Yes.
Counsel, have I?
The people are satisfied.
We're satisfied, thank you.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A4. Probation sentencing will be
25th at 9 a.m. before the
June 25th, 2024, 9 a.m. before Judge Freshour. Bond in this matter will continue. Thank you. Court calls case People versus John Russell.
This is how entertained on behalf of Mr. Russell, who approaches Mr. Russell, please state your correct. John Wayne Russell.
All right.
Your Honor, we just are looking for exam date.
Discovery is complete.
Yes.
People have their witnesses available the 21st.
Yes, Your Honor, for the record, I've read and had it on file, he's confirmed with me that he has it.
All right. Preliminary examination in person will be set May 21st, 2024, 9 a.m. before Judge Valvo.
Thank you. Thank you.
Thank you. Bond continue. Thank you. Court calls case People versus LeJean Smith.
attorney for
Good afternoon. Lon Smith was standing to my right and present.
Okay, your name.
Lon Smith.
What are we doing?
This time we would ask for an adjournment for discovery and possible plea negotiations. Thank you.
Possible. Okay. Probable cause conference will be adjourned May 23rd, 2024, 9 a.m. Bond continue.
What was the date for that?
23rd.
Thank you.
Marion Smith.
This is what found your document. Let's be please state your name.
Marion Smith.
Thank you.
Thank you, Your Honor, for your probable cause conference and failure of seeking an adjournment to continue plea negotiations.
Probable cause conference May 30th, 2024, 9 a.m.
Thank you, Your Honor.
Bond continue. Thank you, man. Court calls case People versus Nicholas Spence. Oh boy, again.
Christina Costantino appearing with.
She was just here in the morning. You need to take your hands out of your pockets.
Who is present in your courtroom. Mr. Spence, can you state your name for the record?
I think it's Spence.
Your name, the date and
And
time
time
set for
set. Go
PCC. We're asking for an adjournment of the
You
PCC.
see, I was just recently appointed. Yeah, it's a routine with you. No, that's fine. Probable cause conference, May 30th, 2024, 9 a.m. Bond continue.
Thank you very much, Judge.
Thank you. You too. She'll be back. She knows. Court calls the case of the People versus Chelsea Carr.
Mr. Canard.
Your name?
Chelsea.
All right. I have before me a plea form. Is that what we're doing? This plea form indicates who wrote this? Wow.
I'm used to typing it out.
No, wow, no. It's better than. but it's whatever it is. I'm just. No. It's like one being better than 0. All right, here we go. All right. My understanding is you're going to plead guilty to count 2, the stated count 2, which is assault and battery, and also to count 3, an added count 3 of use of a controlled substance, a 1-year offense. On your successful plea to those charges, count 1 would be dismissed. That's the court's entire understanding of the agreement.
That's correct, Your Honor.
Should she sign an advice right? Oh, fantastic. All right. May I have her sworn, please? All right, Ms. Carr, it says court's understanding you're going to plead guilty to 2 misdemeanor charges. Is that correct?
Yes.
All right. First charge is the stated count 2 of assault and or assault and battery. That's a misdemeanor punishable by up to 93 days in jail and a $500 fine plus court costs. You understand that?
Yes.
The other charge is that use of a controlled substance. That's a misdemeanor punishable by up to 1 year incarceration and or a $2,000 fine plus court costs. You understand that?
Yes.
All right. You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court.
Yes.
All right. Now, understanding all of that, you still wish to plead guilty to the charge of assault and or assault and battery. How do you plead? To the charge of use of a controlled substance. How do you plead? Now, you understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights from the day. Is that correct? Any question regarding any of those rights? Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form. You understand you're giving up your right to appeal of right. Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty? Has anybody threatened you or coerced you? Doing this voluntarily of your own free will? And because you believe that you are indeed guilty of these offenses? May 24th, 2022, at the location of 522 South Maple Road, City of Ann Arbor, Washtenaw County, State of Michigan. What did you do on that date? Let's start with involving a Brooke Minter.
I got into an altercation with her that ended up in a fight, and I got her in, I guess you would call it like leg lock around her neck and choked her out. And police got called, and I had fentanyl on me, which ended up possession. She's now used it.
Okay, so you had fentanyl on you. Had you used it?
I used it that day, yeah.
Okay, and you knew what you were using was fentanyl. All right. And regarding the altercation with Miss Minter, you basically assaulted her when you were fighting with her. Is that correct? All right. And your actions toward her were all intentional.
Yes.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea? Court will accept the defendant's plea of guilty to counts 2 and 3. Count 1 is dismissed pursuant to the plea agreement. Pre-sentence investigation and report is ordered at 15th District Court. Sentencing in this matter will be
30th at 1:30 before Judge Valvo.
May 30th, 2024, 1:30 before Judge Valvo. Bond with its conditions will continue. Thank you, Ms. Carr. It's the west side of Ann Arbor. Welcome to the west side. Court calls Gate People versus Jonathan Cologne. All right, I have before me a plea form that's typed. Is that what we're doing? It's funny. This one was done by Ms. Hughes. I can read this entire. Okay. The court's understanding is you're going to be pleading guilty to an added count 2 of attempted resisting and obstructing a police officer, 1-year offense. And that upon his successful guilty plea to that charge, count 1 would be dismissed. There's also an understanding of no delayed or deferred sentencing.
That's correct.
All right. May I have him sworn? Sir, it is this court's understanding that you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration and or a $1,000 fine plus court costs. You understand that? You do? All right. And understanding, and I also do have to advise you that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Barr in the 1482 District Court. You understand that? Still wish to plead guilty? And to that charge, how do you plead? And to that charge, how do you plead? Now, you understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form, is that correct? Any questions regarding any of those rights? Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights of that form. You understand you're giving up your right to appeal of right. Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plea? Anybody threaten you or coerce you? You're doing this voluntarily of your own free will. Yes? And because you believe that you're guilty of this offense? On the date of September 6, 2023, at the location of US 23 near Pontiac Trail, did you come into contact with a Michigan State Trooper?
I did, and I just.
What?
continued to keep going. I did.
What happened?
I was already 2 cars up ahead of me, and his lights turned on. At first, I didn't realize it was for me, and I just kind of kept going. Then I realized he was the person of me, and I chose
To keep going.
to not stop. Sorry.
And that was a red bubble was going.
Sorry.
And the red bubble on top of the vehicle.
The red bubble, I honestly was kind of adrenaline pumped, and I made that decision.
Well, yeah. You didn't outrun it, did you?
I didn't stop. I got my license plate, and there was a car behind the door.
Yeah, so all that didn't work out for you, did it? Yeah. Mhm. I don't think in the history of Michigan, anybody's been able to outrun that red bubble. Sooner or later, it's going to get you. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing on this matter will be
July 9th at 10 a.m. before Judge Barr.
July 9th, 2024, 10 a.m.
Yeah.
10 a.m. before Judge Barr. Bond in this matter will continue. All right. And who's that back there with you?
My daughter and
Okay. All right. Mom's back there?
Mom's right here.
Yeah, no, the reason, ma'am, the reason I asked is when he came up, your neck got a little bit longer because you were watching everything that was happening with your son. I'm just saying, I was just paying attention, so I just need to know who that was. All right. Thank you. You guys take care. Court calls the case, People versus Travis Springborn.
Under the Apple, bring on behalf of Mr. Springborn. Please give me the record.
Travis.
Thank you.
This time people will be moving to dismiss this case without prejudice. There was an issue regarding restitution that that money has been set by the court and received by the victim without following on.
Any objection?
No.
Yeah, she didn't think so. All right. Springborn, take care. Case is dismissed. Let's call the case, People versus Troy Swope. Yeah, I bet. Where is he?
He is at the Samaritan Behavioral Center. For this prosecution, I have spoken regarding this via text over everything to them regarding this. I thought the court already had that because they do not get that.
Yeah, you should have led with that.
Covering this from excuse, she did indicate that we would be, there was an agreement for it.
Jeremy, how long are they gonna be in for a period of time? Is that still? Okay. Why don't they? Then let's do this, June 6, 2024, 9 a.m. Court does recall the case, People versus Michelle Cobbleflesh Blessing. I think I got that. You're right.
Ignore the first L.
Ma'am, state your name.
Michelle, Cow Flesh Blessing.
Thank you. All right, what are we doing?
We're asking to adjourn the probable cause conference. We have applied her to substance abuse court in Alcona County. That process remains ongoing. She needs to do a substance abuse evaluation there. And I believe she's in the process of scheduling that.
All right,
Yes,
you
ma'am.
haven't yet, ma'am?
I'm sorry.
You have not scheduled it yet. You're in the process of trying to do
I-
that.
Exactly. I should have it. I will be able to have it scheduled by probably the middle of the month, like the 16th, 17th. Because
Okay.
I don't have the money right at the moment to pay for it, but I just picked up a new job and I get
Got
paid
it.
on the 15th.
Okay. June 6, 2024, 9 a.m.
Thank you, Your Honor.
Bond continued. All right, thank you, ma'am.
Thank you.
আমি আছি বগুড়ায়, আর বগুড়ার সব সেরা রাঁধুনিরা তাদের হাতের খাবার নিয়ে চলে এসেছেন। কেমন করছেন তারা, চলুন দেখা যাক। দর্শক, অসংখ্য প্রতিযোগীর মধ্য থেকে প্রাথমিকভাবে বাছাইকৃত প্রতিযোগীরা আজ হাজির হয়েছে বগুড়াতে। প্রত্যেকের স্বপ্ন একটাই, হতে চায় সেরা রাঁধুনি, এবং একটু পরেই তারা মুখোমুখি হবে বিচারকদের। তারা কি ভাবছেন, মনের মধ্যে কিরকম দুশ্চিন্তা হচ্ছে, কে কি রেসিপি নিয়ে এসেছেন এবং তাদের জন্য কতটা সহজ হবে ঢাকায় যাওয়ার টিকিট পাওয়া, কথা বলবো প্রতিযোগীদের সাথে। দেখি তারা কি ভাবছেন। কেমন আছেন?
ভালো আছি, আপনি ভালো আছেন?
আপনার রেসিপি কি?
আমার রেসিপিটা হচ্ছে ক্যারামেল অরেঞ্জ ইয়োগার্ট।
ওকে, এটার মূল ইনগ্রেডিয়েন্টস কি?
এটার মূল ইনগ্রেডিয়েন্ট হচ্ছে দই, বগুড়ার বিখ্যাত দই। আমি সেটা দিয়ে ফিউশন করার ট্রাই করেছি।
আপনি এর আগেও অংশ নিয়েছিলেন, সম্ভবত 1427 এবং গ্র্যান্ড অডিশন থেকে বাদ পড়েছিলেন, রাইট?
রাইট।
এবারের রেসিপি কি?
এবারের রেসিপি হচ্ছে আমার চকলেট মোকা স্ট্রবেরি চিজ কেক। অল আর মাই সিক্রেট রেসিপি, সো আই এম ভেরি এক্সাইটেড।
কুমু, কেমন আছেন?
ভালো আছি, আপনি কেমন আছেন?
খুব ভালো। এর আগে 1427 লাকি 7 থেকে বাদ পড়েছিলেন, এবার কি মনে হচ্ছে?
প্রথমবারের যে অভিজ্ঞতা, বর্তমানে আমি তারপর আরো 2 বছর সময় নিয়েছি, শিখেছি, তো নিজেকে এবারে তৈরি করে এনেছি। ইনশাল্লাহ ভালো কিছু একটা হবে।
আপনার রেসিপির মূল বৈশিষ্ট্য কি?
আমার রেসিপির মূল বৈশিষ্ট্য হচ্ছে গ্রাম্য নিয়ে এসেছি, মানে আমার গ্রামের যে জিনিসপত্র সে প্রেজেন্ট করবো।
একসঙ্গে কতজনের রান্না করতে পারবেন?
আমি যদি বলি, এখন আমাদের বাসায় যত গেস্ট আসে আপ টু 20।
একটু কি ভয় লাগছে?
হ্যাঁ, একটু ভয় কাজ করছে, কারণ ফার্স্ট টাইম কোনো রিয়েলিটি শোতে আসছি।
তারপর আপনার জন্য শুভকামনা রইল।
সো মাচ।
দর্শক, ভয় তো লাগবেই, এবং এই ভয়কে জয় করাই হচ্ছে যে কোনো প্রতিযোগীর কাজ। সেরা রাঁধুনি কিন্তু একটা লম্বা প্রতিযোগিতা, এবং এই রেসে টিকে থাকার জন্য আপনাকে অবশ্যই অন্যদের চাইতে বেটার রেসিপি দিতে হবে, এবং সেই রেসিপির মধ্য দিয়ে কিন্তু যারা আমাদের বিচারক রয়েছেন তাদের মন জয় করতে হবে। সো দেখা যাক কি হয়, আমাদের সঙ্গেই থাকুন। দর্শক, আমাদের মাঝে বিচারকেরা চলে এসেছেন। একটু পরেই শুরু হবে ফুড টেস্টিং এবং সেই সাথে জাজমেন্ট। আমি এবার কথা বলবো আমাদের বিচারকদের সাথে, দেখি তারা কি ভাবছেন। ওয়েলকাম টু বগুড়া অডিশন। কি খবর?
ভালো, তুমি কেমন আছো?
আমি খুব ভালো আছি, এবং আমি ভুল না করলে এবার দিয়ে বোধহয় 5ম বারের মতো আপনি আসলে বিচারকের দায়িত্ব পালন করছেন। বগুড়ার প্রতিযোগী, সর্বোপরি এবারের প্রতিযোগীদের নিয়ে আপনার কি বলার আছে?
প্রত্যাশা তো অনেক বেশি, কারণ বগুড়া সবসময় সব সিজনেই অনেক ভালো ভালো পার্টিসিপেন্টস আমরা পেয়ে থাকি সেরা রাঁধুনিতে। তো এবারেও আমি আশা করছি যে অ্যাটলিস্ট টপ 5 পর্যন্ত যেন যেতে পারে, এরকম পার্টিসিপেন্টস আমরা এখান থেকে নিয়ে যেতে পারি, এটাই আমাদের প্রত্যাশা।
শেফ নাইম আশরাফ দ্বিতীয়বারের মতো সেরা রাঁধুনির অডিশনের দায়িত্ব পালন করছেন বিচারকের। কেমন লাগছে বা কি মনে করছেন এবারের এই আয়োজন নিয়ে?
সে রাঁধুনি গত সিজনে আমরা রংপুর দিয়ে শুরু করেছিলাম, সো এবার বগুড়াতে নতুন পার্টিসিপেন্টসদের খাওয়া ট্রাই করার জন্য ভেরি এক্সাইটেড। রেসিপি সিলেকশনে আমি সবগুলো রেসিপি দেখেছি, সিলেক্ট করেছি, সো ওগুলো খাওয়ার জন্য এবার এখানে আশা করি অনেক ভালো পার্টিসিপেন্টস বগুড়া থেকে পাবো।
অনেক অনেক ভালোবাসা। আমার মনে হয় আমি আর সময় নষ্ট না করি, আপনার ভেতরে চলে যান।
তোমাকে অসংখ্য ধন্যবাদ।
থ্যাংক ইউ। দর্শক, আমাদের প্রধান 2 বিচারককে তো পেয়ে গেছি, কিন্তু বগুড়াতে রয়েছেন আমাদের আরও একজন অতিথি বিচারক। তিনি ঠিক কোথায় আমি এখনও জানি না, তাকে খুঁজে পাচ্ছি না। তিনি এলেই কিন্তু শুরু হয়ে যাবে আমাদের মূল অডিশন রাউন্ড।
আমার মাঝে আমি সেরা রাঁধুনি, mình đã tô xong quả dứa với cái màu cam nha, phần lá là màu xanh nè, còn phần chùm nho này đây là một chùm nho chín nha. Mình đã xong cái màu cam này rồi, mình sẽ tô bằng cái màu tím nha, màu tím nha. Đây là cái màu tím nè. Mình sẽ xếp lại cái màu của mình vào cái hộp màu này. Để cho nó đỡ chặt nha. với những quả nho màu tím nhá. Mình sẽ tô. Một chùm nho rất là nhiều quả nho nhỏ nha. Mình đang tô phần chùm nho với cái màu tím nhá. Một cái giỏ hoa quả gồm 4 loại quả là quả xoài, quả táo, quả cam và quả nho. Mình đang tô phần quả nho nha.
It looked really good. Taste-wise, it is also very good.
থ্যাংক ইউ
কোথায় শিখলে বিফ লাজানিয়া বানানো?
এটাই ফার্স্টে ইউটিউব থেকে দেখেছিলাম অ্যান্ড দেন কয়েকবার বাসায় নিজে ট্রাই করেছি 4-5 বারের মতো, যখন আমার মনে হচ্ছে যে রেসিপিটা পারফেক্ট করতে পেরেছি।
আমি মৌসুমি।
মৌসুমি কি বানিয়েছেন?
এটা হচ্ছে চকো ক্যারামেল চিজকেক ব্লসম।
Looks beautiful. I think আজকের দেখা one of the best presentation.
থ্যাংক ইউ।
কি করেন আপনি?
আমার ছোটোখাটো একটা বিজনেস আছে ফুড নিয়ে, পাশাপাশি আমি ট্রেনার হিসেবে রাজশাহী মহিলা টিটিসিতে আছি। আমি মাস্টার্স কমপ্লিট করেছি হোম ইকোনমিক্স থেকে, আর এছাড়াও আমি হোটেল ম্যানেজমেন্টে ডিপ্লোমা করেছি, আর এখন করছি হলো কুলিনারি আর্টসের উপরে ডিপ্লোমা। এছাড়াও আমি কিছু লেভেল কমপ্লিট করেছি যেটা কুকিং এবং বেকিংয়ের উপরে।
সো আপনি রাজশাহী টিটিসি ট্রেনার?
জি।
সো রাজশাহী টিটিসি ট্রেনার হিসেবে ইউ হোল্ড আ ভেরি হাই পজিশন ইন দ্য সোসাইটি, রাইট? সো ওই পজিশন থেকে এসে এরকম একটা প্ল্যাটফর্মে দাঁড়িয়ে নিজের খানাকে প্রুভ করা, দ্যাট টেকস আ লট অফ গাটস। অল ইউর স্টুডেন্টস আর ওয়াচিং, যারা আপনাকে চিনে তারা দেখছে।
জি।
অ্যান্ড এটা তো অ্যাবাউট নাও তো 50-50, ইট ক্যান গো এনি ডিরেকশনে। ফুড প্রেজেন্টেশন নিয়ে আমি বলেছি, ইট লুকড রিয়েলি গুড। টেস্ট ওয়াইজ ইট ইজ অলসো ভেরি গুড।
থ্যাংক ইউ।
এভরি লেয়ার, ডিফারেন্ট এলিমেন্টস অফ ইট ভালো লেগেছে।
জি।
নিচের সসটা ভালো লেগেছে।
থ্যাংক ইউ।
আমাদের যদি সিলেক্ট হয়ে যান তাহলে কিন্তু একটা লম্বা সময় থাকতে হবে, মানে এত কিছু বাদ দিয়ে ওইটুকু কি করা সম্ভব?
সম্ভব, কারণ আমার বাচ্চারা খুব করে চায়, এটা তো আমার ভালো লাগার একটা জায়গা যে আমিও চাচ্ছি এখানে যেতে। সঙ্গে আমার বাচ্চাদের খুব ইচ্ছা যে তার মাকে এই পজিশনে দেখা যাক, তো আমি হয়তোবা জবও ছেড়ে দিতে পারি এখানে যাওয়ার জন্য।
মৌসুমি, আমরা আপনাকে ওয়েটিং কার্ড দিব, ঠিক আছে?
থ্যাংক ইউ।
আসুন।
ইয়েস, পেয়ে গেছি আমার কাঙ্ক্ষিত কার্ডটি। যদি আমি অ্যাপরনটি পেয়ে যাই তো আমি যেখানে জব করি তাদেরকে আমি জানাবো আমি ছুটি চাই 2 মাসের জন্য। যদি তারা মানে রাজি হয় তাহলে ওকে, আর যদি না রাজি হয় তো আমার স্বপ্ন পূরণের জন্য আমি জবটা ছেড়ে দেব, তাও আমি যেতে চাই ঢাকা।
আসসালামু আলাইকুম।
ওয়ালাইকুম আসসালাম।
আমার নাম তাসনিয়া আলী।
কি বানিয়েছো আজকে?
আমি বানিয়েছি বিফ লাজানিয়া।
কোথায় শিখলে বিফ লাজানিয়া বানানো?
এটাই ফার্স্টে ইউটিউব থেকে দেখেছিলাম অ্যান্ড দেন কয়েকবার বাসায় নিজে ট্রাই করেছি 4-5 বারের মতো, যখন আমার মনে হচ্ছে যে রেসিপিটা পারফেক্ট করতে পেরেছি।
সো এটা পারফেক্ট আছে?
আই হোপ সো।
ইটালিয়ান আইটেমে কোন উপাদানটা ছাড়া কখনো ইটালিয়ান ডিশ হয় না?
টমেটো আর মজরেলা, ওদের প্রত্যেকটা আইটেমে কাইন্ড অফ এই দুইটা জিনিস কনসিস্টেন্ট থাকে।
অরিগানো অলসো।
অরিগানো অলসো, ইয়েস।
এখানে মজরেলা আসছে?
জি, হোমমেড মজরেলা যেটা আমি নিজে বানিয়েছি।
হোমমেড?
জি।
I am very impressed যে you make your own mozzarella.
থ্যাংক ইউ।
আর কি কি ইটালিয়ান ডিশ তুমি ভালো তৈরি করতে পারো?
স্প্যাগেটি উইথ মিটবলস, এটা ফ্রিকোয়েন্টলি বানাই। আরেকটা হচ্ছে তিরামিসু।
বাংলা খাবার বানাতে পারো?
জি পারি।
5 ফোড়নে যে ব্যবহার করা হয়, 5 ফোড়ন নাম শুনেছো?
জি।
5টা মশলার নাম বলো তো।
মেথি, মৌরি, কালিজিরা, জিরা, নর্মাল জিরা অ্যান্ড না সরি লাস্টটা মনে পড়তে
রাঁধুনি থাকে ওর মধ্যে।
ও হ্যাঁ, সর্ষে
রাঁধুনিও থাকে, রাঁধুনি থাকে। মনে করেন আপনি সেরা রাঁধুনি হয়ে গেলেন,
জি,
15 লক্ষ টাকাও পেলেন,
জি,
দেন করবেন কি?
আই থিঙ্ক কালিনারি আর্টসে একটা ডিগ্রি পারসিউ করব ফার্স্ট অফ অল। অ্যান্ড বেকিংয়ে আমার আরও বেশি অনেক কিছু, যে অনেক টাইপের আইটেমস আছে, সো ওগুলো আমি আমার প্রফেশনালি শেখার ইচ্ছা আছে। তো আমি মোস্ট প্রবাবলি স্কিল বিল্ডিংয়ে ইনভেস্ট করব সবার ফার্স্ট।
So for now, we'll give you a waiting card. ঠিক আছে?
Mình đang tô phần lông của chú vịt mẹ với cái màu tím nha. Chú Khắc ơi, cái giấy khai sinh đấy có cần ngay hôm nay không? Hôm nay cháu không đi công chứng được, nếu mà cần ngay thì phải dùng bản sao. Nhưng mà hơi tiếc bản sao vì hôm đấy nhà cháu làm có mấy cái. Tưởng là chưa cần ngay để mai cháu đi công chứng thì lấy bản công chứng. Nhưng mà nếu cần ngay thì để lại nộp bản sao vậy. Bản sao hôm đấy nhà cháu lại làm hơi ít. Làm có 5 cái thì lại nộp hôm trước một cái rồi hôm nay 2 cái nữa là 3 cái. Thế thôi đưa luôn, hôm nào cháu lại đi làm vậy. Tưởng là chưa cần gấp ấy thì là để cháu công chứng thì nó dễ hơn. Công chứng thì công chứng ở đâu cũng được, nhưng mà bản sao thì phải đúng ủy ban. Vâng, cần luôn thì lấy luôn. Vâng. Thế chú nhé. Mình đã tô xong với cái màu tím rồi nha. Mình sẽ cắt cái màu tím lên đi. Với phần lông của chú vịt con mình sẽ tô bằng cái màu vàng nha. Với cái phần mỏ và phần chân cũng vẫn là cái màu nâu. Mình sẽ tô bằng cái màu nâu này.
15 লাখ টাকা পেয়ে গেলেন, এরপর কি করবেন?
আমি নিজের নামে একটা রেস্টুরেন্ট ওপেন করতে চাই, এটা করতে পারবো, এটা করতে পারবো।
15 লক্ষ টাকায় রেস্টুরেন্ট হবে না তো?
8 বছর চাকরি করেছি মানবাধিকার সংস্থায়। চাকরি চলাকালীন আমি কোনো কিছু শিখতেও পারছিলাম না, এই বিষয়টা নিয়ে আগাতেও পারছিলাম না। সেজন্য আমি চাকরি ছেড়েছি, এটাতে আগাবো বলে। আমার রেসিপির নাম হলো ভেলভেটি কোকোয়া ক্রেভিং।
জান্নাত, কি করেন আপনি?
আমার একটা অনলাইন পেজ আছে যেখানে বাসায় ফুড বানিয়ে সেটা কি বলে সেল করি। কারিগরি প্রশিক্ষণ কেন্দ্র থেকে কয়েকটা বেকিং এবং কুকিংয়ের উপরে সার্টিফাইড কোর্স করেছি এবং বর্তমানে এখন ডিপ্লোমা কালিনারি ম্যানেজমেন্টের উপরে ডিপ্লোমা করছি।
কেন এত পড়াশোনা করেছেন কালিনারি নিয়ে?
নিজেকে একজন প্রফেশনাল শেফ হিসেবে দেখতে চাই।
যখন প্রফেশনাল শেফ হয়ে যাবেন, আমি লাস্ট 7 বছর ঈদে কখনো ছুটি নেইনি। সো ঈদ কমপ্লিটলি গন, হলিডেজ কমপ্লিটলি গন। ফ্যামিলি এটা রাজি হবে? ফ্যামিলি মানবে?
আমি 8 বছর চাকরি করেছি মানবাধিকার সংস্থায়। চাকরি চলাকালীন আমি কোনো কিছু শিখতেও পারছিলাম না, এই বিষয়টা নিয়ে আগাতেও পারছিলাম না। সেজন্য আমি চাকরি ছেড়েছি, এটাতে আগাবো বলে। আর চাকরি যখন করেছি তখন আমার ছেলেকে আমার মা, আমার বোন ওরা হলো কি দেখাশোনা করেছে।
আপনার কেন মনে হচ্ছে যে সেরা রাঁধুনি সেই প্ল্যাটফর্ম যেটা আপনাকে শেফ হতে সাহায্য করবে?
যারা এই কালিনারি জগতে আসতে চায় তাদের জন্য একটা সেরা প্ল্যাটফর্ম হলো সেরা রাঁধুনি। সব কিছুর একটা শক্ত হাতের প্রয়োজন হয় কোনো কিছুতে সামনে আগিয়ে যেতে। তো আমার কাছে শক্ত হাত সেই সেরা রাঁধুনিটা।
শেফ আমরা কি করতে পারি বলেন? নিয়ে যাই
ওয়েটিং কার্ড
দিয়ে দিচ্ছি।
4 বছরের অপেক্ষা।
কি নাম তোমার?
ফাতেমা খাতুন ঋতু।
কি বানিয়েছো আজকে?
ডেজার্ট বানিয়েছি হানি সানফ্লাওয়ার। আমি এখানে বাকলাভা করছি ক্রিম চিজ দিয়ে, যেখানে আমি ক্রিম চিজে ইউজ করেছি হানি।
সো দিস ইজ আ
বাকলাভা এবং চিজ।
আউটার লেয়ারটা বাকলাভার
এবং উপরে চিজ কেক।
এন্ড দেন দিস
দম চিকেন। আর ওইটা নান বানাইছি আমি।
এই দুটো রেসিপি থেকে যদি যে কোনো একটা সিলেক্ট করতে হয়, আমি যদি বলি আপনাকে আমি একটার জন্য মার্ক করব, সেটা কি হবে?
তাহলে বাকলাভা চিজ কেক।
কেন?
বাকলাভা আমার বেকিং খুব ভালো লাগে করতে।
কয়েকটি কুইজিনের নাম বলেন।
আচ্ছা, মানে আমি ইতালিয়ান, তারপর এইভাবে বলবো কি পাস্তা, তারপর পিৎজা। ইন্ডিয়ান কুইজিনের মধ্যে আসে বিরিয়ানি, তারপর হলো বিভিন্ন ধরনের রায়তা, রাবড়ি এগুলা। আর টার্কিশ ডেজার্ট করেছি,
টার্কিশ ডেজার্টে বাকলাভা তো আসেই, থাই কুইজিনে হলো টম ইয়াম স্যুপ আছে, তারপরে হলো থাই ফ্রাইড রাইস আছে একটু।
লেটসে আমরা আপনার কাজকে সিলেক্ট করলাম, আপনি শোতে এসে শো জিতে গিয়েছেন,
ওকে
15 লাখ টাকা পেয়ে গেলেন, এরপর কি করবেন?
আমি নিজের নামে একটা রেস্টুরেন্ট ওপেন করতে চাই, এটা করতে পারবো, এটা করতে পারবো।
15 লক্ষ টাকায় রেস্টুরেন্ট হবে না তো?
যতটুকু হোক,
বাকিটা
ছোট হোক বা বড় হোক, যতটুকু হোক আমি করব।
যদি আজকে এখানে সুযোগ না পান তাহলে কি আপনার জার্নিটা থেমে যাবে?
না না না, অবশ্যই না, আমি আবার চেষ্টা করব।
আই লাইক দ্য স্পিরিট, আপনার ফুডের টেস্ট ভালো,
থ্যাংক ইউ।
এখন খুশি হতে পারেন। আপনাকে যখন 15 লাখ টাকা জিতেছেন, আপনি ইমাজিন করতে বলছে আপনি অনেক খুশি হয়ে গিয়েছিলেন।
না না, এমন কিছু না, ঢাকা অবধি যাই তখন হয়তো ইমাজিন করতে পারবো যে আমি অনেকটা একটা ধাপ হলেও এগিয়ে আসতে পারছি।
ইমাজিন করেন আপনি ওয়েটিং কার্ড পেয়ে গিয়েছেন।
হ্যাঁ, আচ্ছা,
পেয়ে গিয়েছেন
সত্যি?
জি, চলে আসুন।
ঠিকই জানি আমার মাঝে আমি সেরা রাধুনী।
Hello, xin chào các bạn đến với kênh YouTube của mình nhá. Hôm nay chúng mình sẽ cùng nhau tô màu bức tranh Một bông hoa mặt trời. Chúng mình cùng tô màu nha. Một bông hoa mặt trời, mình sẽ tô phần đôi môi nha, với cái màu đỏ nè, đây là đôi môi nha. Với đôi môi là cái màu đỏ. Mình đã tô xong nha. Cái màu hồng. Cái màu hồng phấn mình sẽ tô hai bên má nha. Hai bên má bằng cái màu hồng phấn này. Mình đã tô xong một bên rồi này.